This module is devoted to the role that legal system plays in society, and in particular the way that the law impacts on domestic and international business activity. After going through this unit, you shall be able to 1. Understand the concept and nature of legal environment. 2. Appreciate the significance of legal necessities in international business. 3. Analyze the divergence in structures, processes and content between national legal systems and their impact on international business. And lastly, examine the legal risks and issues involved in today's globalized business environment. The law is a series of rules which govern aspects of human behavior. There are a whole series of rules of behavior which determine how we act on a daily basis. The process of lawmaking is a balancing act between different competing interests and value systems. The legal environment of business provides awareness to the structure and functioning of the legal system. It should be noted that all societies are based on some sound pillars of economic, social and political and legal structure. Legal structure is a sine qua non of smooth functioning of a domestic economy, and it reduces uncertainty in domestic and international business operations. The magnitude and dimensions of legal requirements varies across countries and sectors. It is important to understand the effect that the law has on business in shaping both their internal and external environment in which they operate. The structure of the law has been affected by changes in the political environment and globalization. The law does not exist in a vacuum and is not a static entity. It reflects the value of the society in which it is made and changes with them. If a law does not do this, it can fall into disrepute and overturned. The point is that it is very dynamic and keeps on changing with time and circumstances. Let's look at the international legal environment. Legal environment of business means all factors relating to laws and legal orders which affect business and its working. A legal system refers to a system for interpreting and enforcing laws. A legal system incorporates institutions and procedures for ensuring order and resolving disputes in commercial activities as well as protecting intellectual property rights. Legal or regulatory dimension describes the framework of legislation impacting business. It includes all the laws, legal system and judicial system of the country. A business has to work within the framework of a country's laws and regulations. Every business organization has to obey and work within the framework of the law. In the present world, business of any type and size is influenced by government policies, programs and legislations. Thus, the basic legal environment of business is governed by state, country and international laws. This includes laws on what can or cannot be produced or sold, consumer and employee protection laws, tax and other financial laws, as well as many rules and regulations with regard to business ethics, when and how to seek legal advice in case of disputes, etc. According to Donald A. Ball et al., year of publication, each sovereign nation is responsible for creating and enforcing laws within its jurisdiction. Once laws cross international borders, the matter of enforcement is complicated by the necessity of agreement between nations. The same concepts that apply to domestic laws do not always apply to international law. Nature of legal environment. All business conducted is regulated by the law. Every transaction and every relationship is governed by an increasingly complex mix of statutory and judge-made laws. Laws control the business activities in many ways. The level and type of legal intervention by the state is very much a result of the political process. The law cannot be seen in isolation and is closely linked to the political environment. The law is not a monolithic entity. It is formed in different ways and has a number of different categories. This is not surprising given the range of activities that are covered by the law. It is common knowledge that every business entity tries to have a role to influence politicians either directly or indirectly or both. Depending on the situation, this influence is generally used both positively and negatively. Businesses may therefore press for laws to be removed as well as passed in order to protect their position. In the contemporary world, law increasingly considers the international events and is influenced by the process of globalization. International business legislations cover the main laws linked to the three basic categories of international business, which are trade, international licensing of technology, and intellectual property and foreign investment. WTO is a global watchdog which regulates intellectual property rights like patents, trademarks, and copyrights. Business regulations broadly applies to foreign capital, foreign exchange regulations, industrial licensing regulations, trade regulations, and import and export restrictions. Firms involved in international business must be familiar with and obey three laws: law of their home country, the local law of each country in which they do business, and international laws. Business practices which are common in one country may be illegal in another. For example, the bribing of public officials. In short, a legal system is the means and methods a country uses to 1. Regulate business practices, 2. Define how companies conduct business transactions, 3. Specify the rights and obligations of those engaged in business transactions, and 4th, spell out the methods of legal redress for those who believe they have been wronged. There are three kinds of legal system. 1. Common law, based on tradition, precedent, custom, and usage. 2. Civil law, based on a very detailed set of laws organized into a code, also called codified legal system. And third, theocratic law, which is based on religious precepts. Generally, there are four components of prevailing legal systems. 1. Constitutional law. 2. Criminal law. 3. Civil law. And 4. Commercial law. Janet Morrison has pointed out that laws covering trade between businesses in different countries have existed since the medieval period, when the law merchant came into being. The customary rules used by the merchants of the period. These rules relating to the sale of goods and settlement of disputes were gradually incorporated into national bodies of law, codified in the case of civil law countries and part of common law in common law countries. Set up in 1966, the UN Commission on International Trade and Law, called UNCITRAL, attempted to devise a framework to satisfy the needs of business from trading nations of all continents. The result was the Convention on Contracts for the International Sale of Goods, called CISG, of 1980. That is the Vienna Convention, which came into force in 1988. In modern societies, law has expanded into almost all aspects of business. While business people are inclined to see legal rules in a negative light, which become a constraining factor in their activities, but in fact, much law is of an enabling nature. Significance of legal necessities in international business. A legal system refers to the rules of the game on how a country's law are enacted and enforced. By specifying the do's and don'ts, a legal system reduces transaction costs by minimizing uncertainty and combating opportunism. Countries differ in their laws as well as in their implementation of these laws. Legal systems vary significantly from country to country, and it is important to understand the differences. Whenever companies make an attempt to source, produce and or market products and services in foreign countries, they stumble upon vibrant and difficult legal settings. Businesses face a number of legal issues in their everyday operations. Questions relating to such issues must be clearly answered in order to avoid legal complications. Legal systems in each country deal with such questions differently. Today, there are many laws that at every turn a businessman meets law. Business laws are numerous in number and various in forms. In today's business, legal advice becomes a constant necessity. Modern business is more in the nature of a legal contract than a social contract. The laws are enacted to protect the business interests of various groups in the society. It is through this set of legislations that order is maintained in the conduct of domestic and international business. Laws not only protect business, sometimes they also create business as well. Take for example, the emergence of some international institutions like WTO. WTO contains a large number of legal necessities which require very clear insight. The complexity of various laws requires more and more consultants. In this way, international business legislations and business environment interacts with each other. For a foreign firm to succeed in countries with different legal settings, it must carefully analyze the fit between its policies and the legal conditions of each particular nation in which it wants to operate. The point is that for most business issues, international law is basically a question of which national laws apply and how to apply them to cases involving international business. In this context, it is worthwhile to remember that the laws that govern the resolution of international contractual disputes are basically local laws. Moreover, it is very common that foreign subsidiaries and expatriate employees live within the legal bounds of their host country's legal systems. Individuals working abroad must be alert to avoid falling afoul of local laws and police, army or government officials. MNCs are generally aware of the laws that govern all business decisions and contracts. While pointing out the importance of legal understanding in international business, Zinkota and Ronkin have observed that home countries may implement special laws and regulations to ensure that the international business behavior of their firms is conducted within the legal, moral and ethical boundaries considered appropriate. The definition of appropriateness may vary from country to country and from government to government. Therefore, such regulations, their enforcement and their impact on firms can differ substantially among nations. Divergence in national legal system and their impacts. International law plays an important role in the conduct of international business. Not only do nations react to each other's actions, they develop relationships that determine their future actions. Coordination is required to avoid harmful consequences. As countries move towards more and more trade amongst them, there will be less likelihood of conflicts and tensions to occur amongst them. It is always desired that in international business managers should understand three legal environments. The two legal environments of home and host countries in which they do business, and the third one in which relates to international legal environment. International law represents gentlemen's agreements among countries. It may be defined as a body of rules that is binding on states and other international persons in their mutual relations. At a macro level, international law and the bodies that evaluate it affect high-level international disputes and influence the form of lower-level arbitration and decisions. Generally, local laws determine the legal procedures for doing business in a foreign country, and the country whose laws are used is determined by the jurisdiction for the contract. In legal matters, there are two major areas of international business. They relate to operational and strategic issues. Operational issues are concerned with starting of business, enter and enforce contracts, flexible laws for employing labor and exiting a business. Developed countries have more consistent operational features of business activity. These countries have also made it easier to start a business and have a tendency to impose fewer and simpler regulations regarding employees' recruitment. Moreover, they maintain easy regulatory environment in the courts and bankruptcy schemes. Strategic issues affect the process of value creation and shape an international competitor's strategic policy. This is broadly concerned with 1. Country of origin and local content, 2. Marketplace behavior, 3. Product safety and liability, 4. Legal jurisdiction, and lastly, intellectual property rights. There are several sources of international law. They are customs, international treaties, bilateral and multilateral treaties between nations, and international court decisions. Treaties are agreements between countries, are also known as conventions, covenants, compacts, or protocols. International organizations such as the United Nations have provided a forum for creation of many treaties. It is very important to keep in mind that technically speaking, there is no enforceable body of international law, customs, or treaties. However, court decisions establish a defined international legal environment. Treaties and international contracts represent formal agreements among nations or firms that set down rules and regulations to govern their mutual relationships. The International Court of Justice is one of the organs of the UN which creates international law when it decides disputes brought before it by member nations. The court is operative in international disputes between sovereign nations of the world rather than between private citizens and or companies. The WTO defines internationally acceptable economic practices for its member nations. Although it does not deal directly with individual firms, it does influence them indirectly by providing a more stable and predictable legal environment. Let's look at the legal risks and issues involved in today's globalized business environment. Some form of contract regulates many business transactions. When contract disputes arise, there is always the question of which country's laws to apply. Determining whose legal system has jurisdiction when a commercial dispute arises is an important problem of international business. Legal disputes can arise in 3 situations, and they are: 1. Between government, 2. Between a company and a government, and 3. Between 2 companies. Therefore, a discussion of emerging legal challenges confronted in an age of globalization becomes inevitable. The contemporary global business reality is far from fulfilling the WTO stipulations. In this context, the continued debate over many issues, including the protection of intellectual property rights, that is IPRs, becomes an important area of discussion. The WTO's agreement on trade-related aspects of intellectual property rights, called TRIPS, negotiated in 1986 to 94 in Uruguay round, introduced intellectual property rules into the multilateral trading system for the first time. The TRIPS agreement has an additional important principle. Intellectual property protection should contribute to technical innovation and the transfer of technology. Both producers and users should benefit, and economic and social welfare should be enhanced. As per this agreement, IPRs is defined as the rights given to persons over the creation of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. The WTO's TRIPS agreement is an attempt to narrow the gaps in the way these rights are protected around the world and to bring them under common international rules. It establishes minimum levels of protection that each government has to give to the intellectual property of fellow WTO members. The growing power of ideas in the global economy makes the protection of intellectual property a crucial issue in the development of firms' international strategy. And when there are trade disputes over intellectual property rights, the WTO's dispute settlement system is now available. IPRs require protection to 1. Encourage and reward creative work, 2. Stimulate innovation, design and the creation of new technology, 3. Facilitate the transfer, dissemination of technology, that is direct investment, joint venture or licensing, 4. Provide protection for the results of investment in the development of new technology. 5th, give an incentive and means to finance research and development activities. 6th, stimulate and ensure fair competition. And lastly, protect consumers, that is trademarks. Areas of intellectual property rights, that is IPRS, are copyright, protection of distinctive signs, that is trademarks, geographical indications. 3. Other types of industrial property, that is patents, inventions, utility models, plant varieties protection, layout designs of integrated circuits, industrial designs, undisclosed information, for example, trade secrets, etc. The problem in the area of protection of intellectual property, whether in the form of books, music, designs, brand names or software, is tough to conceive but easy to copy. More recently, with advances in telecommunications, data protection for personal details has come into the ambit of legal protection. Legal obligations now cover a wide range of business activities. Legal risk in international business. Legal risk originates when things go wrong in a commercial transaction. For example, the buyer refuses to pay, or the product is of inferior quality, or the shipment arrives late, and or many other problems. The first available recourse in any dispute is to try to resolve the issue informally. Most disputes that arise in commercial transactions are settled informally. If that fails, the firm has to take resort to more resolute action. Such actions can take the form of conciliation, arbitration, or as a last resort, litigation. Most international business people prefer a settlement through arbitration rather than by suing a foreign company. The point is that disputes take place whenever a company enforces a contract, and in the process it is compelled to launch legal action, or when the need arises to defend itself against legal action. As such, international businesses are liable to be exposed to legal risk in a number of ways. As for example, in the contemporary scenario of foreign direct investment, that is FDI, and outsourcing policies of the MNCs, it has become very common that they find themselves involved in a maze of legal complications in foreign environments. Examples of such legal complications are in the nature of fulfilling certain liabilities which relate to 1. Environmental protection law, 2. Dangerous products, 3. Industrial accidents, 4. Employment law and health and safety law, 5th. Contracts with suppliers, customers, subcontractors, and 6th. Risk of dealing with local officials, especially where local regulations are complex and the possibility of corruption arises. A firm could incur criminal liability under home country laws. For example, the US Foreign Corrupt Practices Act. Sooner or later, every international business becomes involved in a dispute with a foreign element. The exposure to legal risk is greater for international businesses than domestic ones, mainly because of multiple jurisdictions. The moral of the discussion is that situations force the companies into a situation of uncertainty, and the needs to deal with uncertainty prompts them to adopt perspectives from which they can better see the future trends and opportunities. Country risk is always present, but its nature and intensity vary over time and from country to country. Let us summarize. The legal environment of international business refers to the relevant laws and regulations under which the business operates. The basic legal environment of business is governed by state, country, and international laws. When operating international business, it is important to understand the laws, codes of practice, and service charters that govern the behavior in the foreign marketplace. International law comes from 3 main sources: customs, international treaties, and national and international court decisions. The International Court of Justice was established by the United Nations to settle international conflicts between nations and not between individual parties such as firms across national boundaries. While there are laws for functional business, business is supposed to operate within the presence of laws. In the larger context, there is always a level of regulation, and on occasions that may be helpful to business. MNCs have become increasingly willing to use the courts to challenge allegedly incorrect government procedures which have put them at a disadvantage. Although no enforceable body of international law exists, certain treaties and agreements respected by a number of countries profoundly influence international business operations. International court rulings do not establish precedent but rather apply only to the case at hand. Legal systems and the laws they create differ dramatically in countries around the world. National laws and legal systems directly determine the legal procedures for doing business in a foreign country. National laws also determine the settlement of most international business conflicts. International bodies and policies exist for arbitrating cases that cannot be settled fairly in any given country. The international manager must be aware of the laws that will govern all business decisions and contracts. Business must be operated under the rules and regulations of different national laws. Intellectual property rights may take a number of forms. For example, books, paintings and films come under copyright. Inventions can be patented. Brand names and product logos can be registered as trademarks and so on. The main purpose of protection of intellectual property rights, that is the IPRs, and related rights is to encourage and reward creative work. A functioning intellectual property regime will facilitate the transfer of technology in the form of foreign direct investment, joint ventures and licensing. The extent of protection and enforcement of these rights widely around the world, and as intellectual property became more important in trade, these differences become a source of tension in international economic relations. New internationally agreed trade rules for intellectual property rights were seen as a way to introduce more order and predictability and for disputes to be settled more systematically.